Good morning. My name is Sherry Setfin. We're going to go ahead and get started with the Seminole County Code Enforcement Magistrate hearings for August 13th, 2026. The way the process works is the county will present its case first. It will present any witnesses or evidence that it has. You will not be able to present any evidence until it's your turn to go. You can cross-examine witnesses if the county presents witnesses. However, the process is a little bit informal. It's not so much like a court of law where there is actual back and forth cross-examination. Sometimes that happens, but it's a little bit more informal than that. Once the county rests its case, it will then be your opportunity to go. You can present any witnesses you have or any evidence that you have at that time, and I will make a decision here today. If you are here for a first-time violation, you stand to have a penalty of up to $250 a day imposed if you are in violation and do not correct within the time period provided. If you're here for a repeat violation, you stand to have a penalty of up to $500 a day imposed if you do not correct within the time period provided, or if you are here and there is an irreparable or irreversible situation that is determined, you stand to have a penalty of much higher for that irreparable, irreversible nature. Then after that, I will enter my order. You will know when you leave here today what is expected of you, and then you will receive the order in the mail afterwards. If you do have a copy of the agenda, we don't always follow in order, so if you're here and you're signed in, I promise you will be called. Just bear with us, and we will get to you shortly. So we're going to go ahead and get started. The first case that we're going to call is 26990 Russell Moncrief and Mary Moncrief. And in the meantime, I'm going to go ahead and any county individuals who are going to provide testimony, if you will raise your right hand, please. Alexis, are you able to note who all we have? Okay. Officers in the back. Okay. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
I do. Okay. Now, separately, I'm going to swear you all in as the respondents. If you'll raise your right hand, do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? And can you please identify yourselves in the microphone?
I'm Russell Bruce Moncrief.
Mary Moncrief.
Thank you.
Good morning, Madam Magistrate. My name is John Martin. I'm the Code Enforcement Division Manager, and this morning we bring to you case 26-990. The respondent who is in chambers at this time is Russell B. Moncrief Revocable Trust and Mary N. Moncrief Revocable Trust. The parcel ID is as noted on the screen. Property address is 335 Starbuck Run in Longwood, Florida, within the unincorporated jurisdiction of Seminole County, Florida. This is a homestead property. The violations we're speaking of today are Chapter 71, unpermitted shoreline alterations, and Chapter 40, Section 105.1, unpermitted construction. The case summary, as a result of a citizen complaint, this call came in on 7/2 of 26. The original notice of violation was mailed to the respondent by the St. John's Water Management District on 7/2, and on 7/10, I apologize, and then we responded to the property and also cited the property. We then mailed an amended notice of hearing on August 4th, 2026, and the reason for the no notice of violation in the interim is that we deemed this violation to be irreparable, so we moved to have the hearing today, as opposed to something like next month. The compliance dates originally given by Water Management were 7/17. We gave the Moncriefs until 8/12/26. Follow-up inspections were 7/7, 7/13, and 8/12 of 2026. As of my reinspection yesterday on 8/12, while a lot of work has been done, some of the violations still remain on the property. This next slide shows the property appraiser depicting the owners as depicted, Russell Moncrief and Mary Moncrief Revocable Trust. The next slide shows the warranty deed issued on the property on the 9th day of February 2022. The following slide depicts the violation cited. Chapter 40, Section 105, unpermitted constructions. Chapter 71, permits required for shoreline alterations. The next slide shows the compliance schedule that was posted on the property on 7/8 of 2026, depicting the violations as previously mentioned. The next slide shows the letter that was sent to Mr. Moncrief on July 10th from the St. Johns River Management District advising what the violations they viewed were and what their corrective action was to take place. And in the corrective action, they asked for Mr. Moncrief to stop work, put up silt fencing, which he immediately did. And then he was to submit a written plan of rehabilitation to the St. Johns Water Management District, which he promptly did shortly thereafter. The next slide, I'm going to bring up our Natural Resource Officer, Christine Seckinger, to present and explain to you. This is her field of expertise, and she's a little bit more gifted at it than I am, so I'm going to turn the microphone over to Chrissy.
Hi, good morning.
Morning. You state your name for the record, please.
Yes, Christina Seckinger, Natural Resource Officer for Seminole County.
Thank you.
Why widening the Little Wekiva River is considered irreparable here. Violations of outstanding Florida water protection. The lower portion of the Little Wekiva River flows directly through the Wekiva River Aquatic Preserve. By law, outstanding Florida waters are subjected to the highest level of water quality and anti-degradation protections in Florida. Widening causes heavy sedimentation, permanently lowering water quality, and disrupting protected springs, which state documents explicitly identify as a trigger for irreparable harm. The destruction of delicate microhabitats. So the Seminole County Water Atlas highlights the Little Wekiva River that relies on very specific flow velocities and delicate macroinvertebrate habitats, like slightly undercut banks and root debris. Widening or channelizing a river lowers its velocity, smothers the floor with sand, and completely destroys the native baseline ecosystem in a way that regular restoration cannot easily undo. And conflict with active multi-million-dollar remediation. Local and state agencies have spent years fighting severe erosion and sediment buildup on the Little Wekiva River. The Seminole County government was explicitly recognized with conservation awards for the intensive Little Wekiva River Restoration Initiative, utilizing strict bank stabilization. Sorry, my printout is a little blurry. Okay, meander preservation and, oh, yours is, yes.
Mine may be easier to read.
Yes.
There you go.
And sediment trapping, thank you. Any unauthorized entity attempting to widen the banks would be reversing millions of dollars in publicly funded environmental restoration.
And that's for Joe.
Thank you.
The next slide that we're showing talks about the different designations that Christina just read into record, and Joe Parrish, who is our water quality supervisor, is going to come up and discuss what those mean and what the significance of this piece of the river actually is. So,
Can you first tell me what he did? What happened?
yes, ma'am. He went into the river. Can you advance 1, 2, 3 slides? Yeah. If you see on the picture on the left is Mr. Moncrief on a backhoe. In the middle of the river, you'll see a berm of dirt, a small, not even a foot high piece of dirt. Everything from that piece of dirt towards where Mr. Moncrief is was fill and aquatic vegetation. And he dug all that up and put it on the bank.
Is this in his backyard?
It is.
Okay. Sorry, I'm very visual, so it
Yeah.
was good for me to
Yeah.
see what,
We were going to get there. I wanted to bring you up to speed on what this body of water means and what it is. So we'll go ahead and let Joe talk, and then we'll go back through.
I'm very
what each one are-
impatient also,
It's
apparently.
Understood.
So
Understood.
Sorry.
So back to,
Good morning, I'm Joe
Morning.
Parrish with the Water Quality Program here at Seminole County. So that particular stretch of the river is included as a priority water body by St. Johns River Water Management District. Basically, all the priority water bodies that they've identified have some minimum flow and level requirements, or MLFs, and those determinations, they mandate some very technical evaluations for ecological health, water levels, and flow capacity. It's also an outstanding Florida water. It's been recognized by the state under FAC Rule 62302700 and includes some very strict anti-degradation standards. It's also been designated as a BMAP, or Basin Management Action Plan. That stretch of the river is actually under two separate BMAPs, and those BMAPs have very specific elevated nutrient levels that require some monitoring to prevent water degradation. In addition, the National Wild and Scenic River designation has been placed on the Wekiva River by the U.S. Congress, and the Little Wekiva River is a tributary of that.
thank you, Joe. So we go to the slide here. This slide shows that in the mid-2020, the Seminole County embarked on a journey to restore the Little Wekiva River, about 3,500 lineal feet of the river, and it cost roughly $4.3 million. A lot of that was paid for by grants to restore this river to remove essentially the invasive aquatic vegetation that had taken place, and one of the things it was doing is there was so much sedimentation downstream from Mr. Moncrief's property that it was starting to cause the water to find a new channel up towards homes and trying to dig itself a new pathway. As a result of that, it was at risk of causing flooding, and the invasive species had to go. So Seminole County spent $4.3 million taking that out and cleaning everything up, and then replanting a significant amount of native aquatic vegetation, et cetera. And this was all largely due to the hurricane that had come through prior. So the photographs that you're about to see are true and accurate of what was observed on the dates noted. On 7/2, the photograph on the left, you see the activity, the stop work order, and then on the right-hand side, you'll see underneath the elevated walk bridge, there's a seawall, and there's a set of stairs, and then there's a wooden bridge walkway above that one that's further in on the property of Mr. Moncrief, and we're going to get a closer look at that on the next slide. There's the seawall that was installed and the handrail to the dock. You can see in the picture on the right, from where the silt fence is to your left-hand side of the picture, was at one point the bank of the river, and it's now a widened river.
So how wide was it to start with, would you say?
I would guesstimate prior to the activity starting at any given point from the beginning of Mr. Moncrief's property to the end of his property, it wasn't any more than 10 to 12 feet wide.
Okay, and how large is the property? Do you know? Acreage? What is it?
2.76
acres.
Okay.
So it's a significant amount of bank that was removed, and the issue is, if you remember what Chrissy spoke to about the delicate ecosystem that is along that river anyway, when that bank is disturbed and that bank is flipped upside down, you're losing valuable microorganisms. The macro invertebrates are no longer in existence. The aquatic sea life that's natural and native, and even though there is probably some in that area that was dug up that was invasive, the natural occurring ones, the important ones, were there, and they all provide not only a habitat but a food source. all the way down that river from his house all the way down. It would be no different if this was 5 houses up on the river and they did this. It would all be affecting, the water quality and the ecosystem in front of Mr. Moncrief's house. We move on to the next photograph, shows where the original notice of hearing was posted for the hearing on 7/8, and the amended notice was posted on 8/4. The next slide, the follow-up slide, was photographs showing much improvement, and a lot of stuff was put back. He put the fill back, the double silt fences in to try to protect the turbidity levels. He began his restoration program under the guidance of Eric Quinones with the St. Johns River Water Management District. I do want to note for the record that Mr. Moncrief at no time has drug his feet. When he was cited the next morning, he was in my office. Photograph coming up were photographs from yesterday's inspection. This is, I want to say, a little tributary that comes off of the river onto the Moncrief property. The next slide shows, if you look at the silt fence and you look at the dock, that's the difference of what was removed, and that has not been replaced. And I'm not sure if St. John's is asking for that to be replaced at this point or what their requirements are. I think Mr. Moncrief can better testify to that. But the video on the right that you see playing, you can see how fast that river moves. And everything and anything that's disturbed in that river, it will end up downstream very quickly. At the top of the photograph on the right, you'll see a garden tractor parked, and attached to the garden tractor is a rope, and attached to the rope is a log about as long as me to Mr. Moncrief and about 1.5 feet in diameter that he physically pulled out of the river and trapped it so they could have it removed so it wouldn't end up downstream causing more damage. But for a river to be that strong and powerful to move something that big, you can imagine what a disruption like this could cause downstream. The next set of photographs show the picture on the right-hand side is the walk bridge that I cannot, for the life of me, find a permit for anywhere. There's a tiki hut and a gazebo and that walk bridge there and the steps. Mr. Moncrief has advised on numerous occasions and will testify here today that was there when he got the property. It may or may not have been there when he got the property, but I can't find a permit for it, unfortunately. And when he acquired the property in 2019, there's no permits that indicate that that's even legal on the property. He did tell me that he'd done some repairs to it. On the next set of photographs, you'll see on the right-hand side where a piece of installed seawall has failed, and a piece is being successful. So there's still work that needs to be done here. The seawall itself needs to be permitted both through the Seminole County Building Department and the St. Johns Water Management District. Mr. Moncrief is in the process of getting engineered drawings and topographical surveys to make submission for that. On the next photograph, you will see this is the bahia that Mr. Moncrief put on that dirt that we showed you where he put the fill back. He put bahia down. From my professional experience, bahia is a drought-tolerant grass. It doesn't do very well in the water, but we're hoping that it's going to take root and prevent erosion for such a time that the aquatic vegetations that he's planted in there will have a chance to take root. When speaking about that choice with St. John's, they weren't in love with it either, but they did say that silt fence was indefinite, which we had another argument about because silt fence is not intended to be a water dam barrier, and it's definitely not intended to live forever. So I'm not sure what their expectation is there. It's not one that I concur with. You can see here where the river has actually risen to a point now, and it's trying to fight the silt fence that's in place because it's really not the best application of silt fencing. But so the BMPs are, for silt fencing are absolutely not being followed. But it's of no, yeah, we're going to move on to the next slide. The next slide shows where mail was sent certified on July 10th. and signed for, and one piece was, I guess it's still on its way, but the property was posted. On August 6th, there was delivery of the mail. The slides continue to show how we've made sure we covered our due process rights by ensuring that the Moncrief family was notified of the action and what the requirements were. On the next slide, you see that based on the evidence presented in case 26990, it is determined that the respondent is Russell B. Moncrief Revocable Trust and Miss Mary N. Ron Moncrief Revocable Trust. They are the record owners of the property located at 335 Starbuck Run in Longwood, Florida, in Seminole County as determined by the property appraiser. They are in possession or control of the property, and they are currently in violation of Seminole County Code, Chapter 4105, Chapter 71, 71.6. At this time, I would like to submit this digital and case file into evidence.
Do you have any objections to the electronic case file that has been shown here today, the code enforcement file being entered into evidence?
I'm sorry, do I have an objection to what, ma'am?
To the electronic case file that you have seen up here today and the code enforcement file being admitted into evidence?
I believe everything is accurate.
Thank you. It will be accepted into evidence.
Thank you. This page here is basically a reminder to the court that under Section 162.09 administrative fines fees, under Section 2D, a county or municipality having a population greater than 50,000 may adopt by a vote or at least a majority plus one of the entire governing body of the county or municipality an ordinance that gives code enforcement boards or special magistrate the authority to impose fines in excess of the limits set forth in paragraph A. Such fines shall not exceed $1,000 per day per violation for a first violation, $5,000 per day per violation for a repeat violation, and up to $15,000 per violation, and a code enforcement board or magistrate finds the violation to be irreparable or irreversible in nature. In addition to such fines, a code enforcement board or magistrate may impose additional fines to cover any cost incurred by the local government in enforcing its codes and all cost of repairs pursuant to Section 1. Any ordinance imposing such fines shall include criteria to be considered by the code enforcement board or special magistrate in determining the amount of fine. Based on that, it is the recommendation that you adjudicate the respondents in violation of Chapter 71 and impose a one-time fine of up to $15,000. You find that the respondent is in violation of Section 105.1 and afford them a 90-day time period to gain compliance or a fine of $500 for each day thereafter. And that concludes this presentation.
So let me ask, the permits would be for the dock and railing and steps? What would the permit be for?
Yeah, it's for the dock, the railing, steps, the gazebo and tiki bar, and there may be an opportunity here to, in lieu of complete build permits, there may be repair replace permits that are afforded him this opportunity. So in lieu of having to permit the entire assembly, he may be able to go, this is the assembly, I've done some repairs. And he's done a significant amount of, not a significant, about 40% of rotted wood replacements. So that is something that we need to negotiate with the building department and see what will the building official accept. But like I said, I've dug and dug and dug, and I cannot find a permit anywhere in history for that dock, gazebo, or tiki bar, stairs and railings.
So it would be some sort of permitting?
It would be a building department to address that and the seawall.
Okay.
Yes.
Okay, and for the seawall, okay.
Yes, and then once he satisfies the St. John's Water Management District with their permit, then that permit comes over to us, and then we give him the shoreline alteration permit based on that. But we can't do our part for that until they do their part with that. And there's actually not a timeline requested for that. It was the imposition of irreparable for that.
Well, and so along with that, though, he wouldn't have been able to get a permit for what he did anyway. The removal.
No.
So.
No, it would not have been granted. To go in and do the removal of invasive by hand, he would have absolutely been allowed to do on both parts, St. John's and ours, but to use equipment and to widen the river to that extent, there would have been no permit issued for that.
Okay.
And that's why St. John's immediate response is stop, throw up a silt fence, and put it all back. But as you well know, you can't just put it all back. It's like, can I burn down the senator and then replace it with another 30-foot diameter, 80-foot tree? I cannot.
And does the county contemplate needing to do any restoration, or would it do any restoration itself from what was done? Or do we know, is that something that we wouldn't know for a while because of the future impacts?
I'm going to refer to Chrissy and Joe, if they can come back up and assist in answering that. That's more their level of expertise, but there is, explain the DEP monitoring point and what happens if it's wrong, and what something like this looks like on our end.
Typically, we do some restorations along the Little Wekiva, but they usually go through some requirements, and there are some special, based on that list that I gave earlier, there are a lot of requirements that go into that. But usually it requires a lot of surveys and a lot of information ahead of time.
And you won't know the impacts to this maybe for years down the road?
Correct.
Okay. Okay. All right. Thank you. Okay, the county has closed its case. I've accepted their evidence into the record, and it's your turn now to present any evidence and testimony that you have, sir.
I may need.
All right, thank you, Your Honor. May I approach the bench?
Sure. Thank you.
The other copy of that, I'm going to keep here in case he needs something on the overhead.
Sorry, Your Honor, it's kind of a long motion that I put there, but I tried to put some history in it and a lot of other things. So if you want to take time to read it, or you want me to try to go through it?
Yes, I would rather that you go through it, but you're bringing it forward for the first time today.
Yes, ma'am. Well, I've been in touch with code enforcement from day one when they called me. I immediately went down and spoke with Mr. Martin, and Mr. Martin had several other people in the room with them. I've stated that in here. And they gave me a list of things they wanted me to do and not to do, one of which was, you know, obviously I had a stop work order, and I immediately stopped with a phone call. It didn't have to have a notice posted on my door. There was a lady that called, I want to say Mrs. Hopp, OPP or something. I'm sorry, I don't remember her name exactly. Y'all would know who I'm talking about, the lady that called me. She called my wife, and my wife told me that we had a call. Her, I think first name was Jennifer, I think. And
Jennifer Goff.
Goff, G-O-F-F?
Yeah.
Yes.
She's with our environmental engineer.
And so she called and told my wife that they wanted me to stop work, which we immediately did. And then I went down to see her the very next day, and she called in Mr. Martin and several other people from the code enforcement and stuff, and we discussed the situation in the property that was there. And they advised me to get in touch with Mr. Capata?
Paul Capetta. with St. John.
From St. John's River Water Management District, which I did immediately. I had previously been in touch with him, which is outlined in my motion. He had been in touch with us about other issues and had pretty much closed the book on it at that point in time of anything that. Also in my motion, you'll see there was a conflict with his neighbor who is calling, setting off his alarm clock in the middle of the night, shooting a shotgun, threw an egg at my car. I don't know what all his problems are, but he's decided that I'm public enemy number one and that it's his job to try to make my life miserable, I guess. But if I'm wrong on something, I'm still wrong with it, and I have to correct it, and that's okay. I appreciate that. But the source of it was not from ongoing problems with the river itself. It started with a neighbor being a complainant and calling code enforcement, the dog catcher. I listed several of them in there, Your Honor, they're in there. But I went down and spoke to code enforcement and got a list of things, which included getting a survey, which was going to be asking for a topographical survey with the elevations and everything of the area. I would ask Mr. Martin, if I could, have I been compliant with y'all ever since we first started? Have I been cooperative?
As I stated during my testimony and presentation of the
Right.
case, as soon as it was brought to your attention, you have stopped. You're very responsive. You're willing to meet on property or anywhere we need you to meet to discuss what needs to be done. And yes, you are making positive efforts forward and have been.
And as outlined in the motion at the very last, I've gone through considerable expense so far that I had not anticipated dealing with. I'm somewhere around $18,000 right now that I've spent on things. I was at the instructions of St. John Water Management District. They asked me to get Bahia, which I got 10 pallets of Bahia at a $1,400 expense, and paid people to spread that out for the sole purpose of stabilizing the dirt. The dirt that came out is the dirt that I put back. And also in my motion, let me correct a couple of things for the record, if I may, Your Honor. We bought this property in early 2014 as a trust. I lost my trust papers, and I went to a lawyer, and I told her, hey, I want to get, can you reproduce this trust for me? And I can't find the paperwork. And it was a nice trust. It was well documented with things. And she said, it's just going to be easier to make a new trust. And so she made a new trust, which I don't like. I'm going back to, I found the paperwork. I'm going back to the old one. And then she, in 2019, I guess it was, gave the deed. If you look at it, it's from a trust to the trust.
I saw that.
The original purchase date was back in 2014.
Okay.
At that time, and I'll say that under oath as testimony, at the time that I moved into the property, and my wife can testify to it also, that all of the structures that are down by the water were in place at the time of our purchase. So that construction was not done. Now, I have replaced some of the bad wood on the same footprint that existed. I did not expand the footprint. It was the same footprint that's been done. A board came out, a piece of, actually I used plastic wood so it wouldn't continue to decay. Much more expensive, but that's what I've replaced it with. I've tried to improve the area. In the pictures that you'll see that are included as exhibits, Exhibit C, at the time that we purchased this property, this area right next to that I dug out was, the river was there. That went right up against my structures. I would go off the structures into the water. Over the past several years, let me look at, it's C1, 2, 3, 4. This is back, these are from 2019. I found pictures from 2019. But you can see, starting on C5, if you look at picture C5, Your Honor, I had it blown up best I could. If you look through those palm trees, you see that sand? That's the area that I've dug out now. Okay? That sand was deposited by the river by other people's construction upriver and stuff, and when there's high water, when it rains a lot like it has recently, the water will rise as much as a foot or two. And then it deposits things on the ground. And when we've had hurricanes, I've had the water go up halfway to my house. But all of this area that is sand right there, that was water coming down by my house. You can see where it goes real close to the palm tree right there. That palm tree on the left, the water's going right by it. You see the contour of the ground, how it goes by the steps. Those steps are where the gazebo is. This is a very poor drawing, Your Honor. I am not an artist. May I approach the bench?
Sure.
Here, I'll take it, sir. Appreciate it.
Okay.
Can the county see that, or is there a copy for the county?
I'd be glad to give you a copy. I have a few extra here. Here.
He has
Would you
an
like one?
extra.
Yes. Thank you.
Okay.
Thank you. Pardon me.
I think that Mr. Martin has seen this sketch before,
Many times.
but this is currently how I have replaced with the, if you look at it looking straight down, you can see the river, an aerial view coming straight down. At the very top of the page is the bridge, it's a suspension bridge that goes across to the island. And the walkway that exists there, it goes on my property and connects the tiki hut to the gazebo. And on the lower left, in the center, lower center, there's a little canal that was underneath that. That's all blocked up to the river, but that's the hand bridge that I think you were talking about before. It's a little small bridge there that I walk across. But
Did you place the gazebo and tiki hut?
you see in the very center of the page, there's a round circle with a bunch of X's around it. Those X's represent a deck around the gazebo.
But did you place the gazebo and the tiki hut, or were they there when you purchased?
They were all there when I bought the place, Your Honor, as well as the suspension bridge, as well as this other little bridge down here by the lower center of the stage. Those were all on the property at the time that I purchased it.
Did you do, when you purchased the property, did your title company do a municipal search to where they checked to see whether there were permits for all the structures on the property?
I don't know what they do, Your Honor. I got title insurance from the thing. It was a gift to God for me because it's a very nice piece of property.
Take your time.
Phew. The property extends from the road about 600 feet long
Okay.
to the other side of the island. On the right here, my property goes to about the middle of that island. And so I own all that land, except because it's a public waterway. I guess I don't own right where the river is there.
But you own on both sides of the
I
river.
probably own the land under it, but I
Okay.
can't own the water, but which is fine. But the water used to come through my neighbor's property, and I don't want to throw my neighbor under the bridge. I've told them. My neighbor to the south of me is an attorney for Florida Hospital. Nice enough guy. We don't talk a lot, but he extended his area into a beach, making a beach for himself for a while, and tried to keep it a beach, but eventually overgrew. And then I think that he's added some more land to build it up a little bit. But that caused the river to go and divert a little bit to the right, which caused an erosion on this river, the bank over here. That used to be a straight shot down underneath my bridge. And it used to come across his property from his bridge. He has a bridge. It went straight right beside the gazebo, and then real close to that palm tree, even closer than this sketch. The sketch shows that I had put the corrugated pilings out there to keep it from eroding further. And I almost could see the ball of the palm tree when I first got it. It was being held, and it's still there now. There's a big old cord holding the tree up. And so that's on some of the pictures. You can probably see that strap holding it up. Well, I put the corrugated out there far enough out so that I could have dirt around the palm tree and keep it more stable. And it came right beside the steps of the tiki hut, which is at the top of the place. And that was where the water flow was. And that's when I bought the property. Now we've had hurricanes since then, and there's been road construction, and I've got a thing that Katie's Landing, and the Friends of the Wekiva took up with the Sentinel, and they made a big thing, and I probably ought to be introducing all that stuff as evidence, which I can. I got it with me. I didn't have time to put it all in the motion. I did a lot of work in the last 24 hours on this motion, Your Honor, but the water across where I dug out, I didn't dig into the river that was there. I dug away the sediment that's been coming down and planting itself on my property over the last 5 or 6, 7 years. And pictures of 2019 shows where it was at and shows the beach on page C5. You can see that. Now, let me see if I can find some other stuff that show it. You can see on C3 how the water, you can see the chair there. That's from the deck of the tiki hut. And if you look at the bottom right next to that chair, the water's right there next to the deck. Okay? And if you look upriver on C5, you can see the water's going right by the steps of the gazebo. That's in those pictures. And then all that sand is white sand. It's not microbes and everything. That's the stuff that's coming down river and depositing on my property. Now, I'm not saying there's not some muck underneath it somewhere there. That could be. But the river that I was digging out was the river that existed before. I was trying to restore my shoreline. I wasn't trying to widen the river. And my effort was to restore my shoreline. And when I did it, I left a nice big heavy berm. The river was low. It wasn't a lot of rain right then. But I left a big heavy berm of dirt and mud, which kept, and everything I was doing was not getting in the river. It was not. Now, St. John's Water Management District and the county asked me to put the silt fencing up, which I did, and I'm glad that I did. I like it there now. It's doing a good job. Now that the water is rising, it's doing its job. The river is nice and clean. It was crystal clear when I was working, but now it's a lot of tannic in from the rain. But the river as it existed and all those structures that are down there, the structures that were down there were there when I bought the property. Now, if they need to be permitted, Mr. Martin is working very graciously with me to try to see what we can do about pulling a building permit, and I have to get an engineer who's going to have to come out and reconstruct what's there. It's a nice, strong structure. The man knew what he was doing when he built it. Mr. Oliver used to own Certified Slings, and he built that bridge with 3/4-inch stainless steel cables, like 12 of them going down from atop of some telephone poles that are anchored in cement, and it's very well built. If it were bigger, I could probably drive a car over it, but it's no problem at all driving my lawnmower over it. And it's high enough up that it does not obstruct any canoes that want to go down the river. I can't say that for the bridge down the river by the man that's lodging all these complaints, but his bridge is like 6 inches off the water. Everybody that wants to canoe has to port around it and go back in the water. But this area here had been growing up. It had gotten to soot. I have small grandchildren. They like to play in the water. It was becoming a endangerment, which I listed in there. I don't want to breed water moccasins. I would draw attention to Exhibit B. B1, 2, and 3, please. This is a letter to me dated in 2019 from Nicole Martin. No relative of Mr. Martin, I don't believe, but she's with St. John's River Management District. And in this letter, she addresses the building and the bridge, and she said that she was able to do research, and she was not able to find any permits that had ever been pulled on it. But she did research and found that the bridge was still there back in 2005, which was long before I bought it, and has been there a long time. She went on to point out that pursuant to Florida statute 403.813, which is on page B2 on the back side, she was pointing out exceptions to permitting rules. And those exceptions required that if it's going over the water, you can get permission and you can get permits. You can get permits to go over the water and build a dock. And if they did that, it would disturb the soil. So it's not like anytime you disturb the soil, you're going to mess up the microbes there, but you're not destroying the river. But I didn't build anything over the water. Okay, that building was already there beside the water. But she went on to say and show the 5 things that were required to be fallen in the exception, and she felt as though this fell into the exception, and she went on and gave a conclusion there somewhere that, find out where it's at on which page, but if you read it all, it's in there, and I summarized it in my motion. And then she went on to say that under the general permit for installation, that a general permit is automatically permitted. Now, I'm not trying to avoid getting a permit from them. I'm willing to do whatever they ask me to do to get a permit, and St. John's Management District. I have already applied to St. John's and paid them their fee. It's like $490 so far, and I've already applied for one of the permits that I was required for a dredge permit for the county, and I paid $750 for that permit to get it done. And I'm trying to get the requirements that I need for a building permit to go back on the building and get a permit for the structures that are there, but I have to get an engineer yet, and the one I called has not responded to me. I'm going to have to find another one. The first surveyor I found wouldn't do it, but I did find another surveyor. He's going to charge me $2,700 for a topographical survey. I've already paid him $1,300, the balance when he finally does it and gets it to me. I need to get those things in order to make the application to the county. Am I correct in that?
You are, sir. Yes.
Those applications that I can make now, I have done so. Is that not correct?
It is.
Okay, and I want to point out to you, the statutory information that she was giving you was related to permits for her, not in the state. They were not related to permits for the county. Those are
I recognize that
okay.
she is with the state and not the county.
So the county's
In her
permitting.
letter, she even states that I should check with the county on things. But I wasn't doing anything at that point to be going to get it. I mean, the building was already there.
Sure.
I didn't feel that it was incumbent upon me to come along.
What was the purpose of this inquiry from her?
I had a gentleman named Dave Kramer. I have a lot of water that would run down my driveway, and it would tend to wash it out, and I was trying to slow that water down, and he was helping me build a rock berm in my driveway.
Okay.
And then I had talked to him about what would it take to do some work along the river and try to make that stabilize and stuff. And so he had contacted her, I believe, and she came out. He's mentioned in her letter,
Okay.
Dave Kramer and stuff. And then, and her conclusion of the structures that were there, and she wasn't guaranteeing everything. I'm not saying she was, but I'm saying that the input that I had could lead a reasonable person to think that it's potentially not a problem the way it is, and that I'm not necessarily under the gun that I have to go out and get a permit for something that's already done. If I want to build something else or...
Well, let me explain to you, you are responsible for permits for everything that's on your property.
Okay.
So even if the people before you didn't get them, and I see cases like that all the time. So there'll be someone who has a shed in their backyard, they didn't know it didn't have a permit. They're so responsible, which is why I asked you if your title company did a municipal search at all. But
I don't know.
and that's okay. But separate and apart from this, if there was an inquiry made of the Water Management District in 2019 regarding possible work that you were doing on the shoreline,
Okay.
why didn't you contact them again before you started bringing in heavy equipment and digging out the shoreline in this instance?
Well, I tried to use a shovel at one point on the stuff. And I'm 76 years old, 77 years old, Your Honor. And I had access to these boards, plates that you can put on soft, mucky ground so that they don't sink and you would have gotten stuck in stuff. And I was able to dig alongside of the wall that was there, that retaining wall that I had put in a couple of years ago. I was digging an area about 6 feet wide. You can see where the berm was. And that's what I was getting, the excess dirt that had been deposited, and clearing that out to a depth of about 4 inches, and just taking all that dirt off, and that's what had piled up on the top. And then I wanted to put one of those corrugated walls along where the river used to flow to keep it from eroding away and trying to restore the original, what is it called, shoreline. That's what I was wanting to try to do.
But what made you not contact Water Management District if back in 2019, when you were talking about it, there was contact with the Water Management District?
Well, Dave contracted them, and they came out and talked to us. I don't know exactly what Dave had in mind for trying to do with the water. That we didn't do it. He was talking $100,000 to work on the river, and I said, Dave, I don't have that kind of money. I said, I can't do anything there. And so that didn't go anywhere because I couldn't afford it. And so we finished the little thing down the driveway that kept the water. We slowed the water down so it didn't keep washing it out by putting big rocks and little rocks. But that was way away from the water. That was just in my driveway. As it goes down a steep hill, we just slowed the water down so it didn't rush through there. Now, in my brain, as tiny as it is, Your Honor, and I am wrong now, I'm made aware of things. I did not feel as though I'm widening the river. I felt as though I was removing the sediment that had dropped on my waterline shoreline, and I'm restoring my shoreline is what I felt like I was doing. And I've been made aware of it. I'm trying to pull the right permits now. I've already paid for a dredge and fill permit. I've been working with St. John's River Management District. They wanted me to not only plant the sod that I planted, but they wanted me to plant some indigenous plants to the area that would grow up and spread and take over and be like they want it to be, which I understand, but I can't bring in giant plants. I mean, I bought $2,700 worth of plants.
No, I understand that, but let's, and I understand that you're working toward fixing all of it, and I understand that you did not think that you were doing anything to widen the river.
Right.
But now, here we are.
And
And
I've
so-
been made aware of that.
So you have a motion, and what exactly, if you're asking for more time, are you asking for time to come into compliance? Or in your motion, or are you asking, because the county has indicated that they're willing to give you time to get the permits that you need to get. So I'm not really sure what you're asking for in your motion.
I'm asking for the additional time, which would carry me into January. And I expect to not just get a permit, I'm hoping to get permits within the next 30 to 60 days. But I would like to finish all the projects that have to be done and have everybody close those permits out and say, okay, you've got the permit, you're in compliance now with this, we can close out. On the permits on the buildings that are there, I think that they can be opened, inspected, and closed out relatively quick. St. John's Management District wants the plants to grow. They've asked me to keep them posted. I call the man at least twice a week he wants me. I'm going to try to call him every other day.
But what the county is asking for is just for you to get the permits. They're not asking for the full closeout. They're asking for you to go through the process to get the permits, and they're giving you 90 days to do that.
Madam Magistrate, if I can elaborate on that as well. The reason, and you did notice that I didn't ask for permits with passing final inspection, and thank you for noticing that. The nuts and bolts of this case is that this case will not be closed by St. John's, nor will it be closed by our environmental team for years. Once the actual rehabilitation permit is opened and granted, there is a rehabilitation plan that will take place on that property, and that plan will consist of potentially up to 5 years of monitoring, be it by him or by allowance of permission for the state and the county to gain access to the property, to the river, to monitor said river and the impacts thereof. So this is, the 90 days is, hey, I need you to get all your permits done in this time window.
Right, and then if you don't follow through with all of those steps during that process while the permit is active, you could see yourself back here if you weren't following through with what needed to be done. But we're talking first stage here.
Right.
So they're saying they're willing to give you 90 days in order to get those permits.
Well, I'm hopeful. I'm restricted on that. I can't, I'm happy to go out right now today and pay the $500 for the second permit. I've made application for the one, but I can't even make the application until I get the survey back and get the engineer to give me those drawings, and I have to depend on other people that are proven to me in life that people are not always as diligent as they represent themselves to be.
Understood.
And so I'm hoping that they will do something expeditiously, but my engineer hasn't even called me back, and I've been, I've reached out to him 2 weeks. It's in my motion that I used him on another project. It was a much smaller, it was just a mobile home that needed to have some windows drawn for a new window that was going into it. And he
On
charged,
this property?
No,
No, ma'am.
no,
Okay.
this is over in Polk County.
Okay.
And he charged me $1,000 to draw some window framing around some mobile windows. And so I don't know what he's going to charge, but I expect it to be a couple of $1,000s that he's going to end up charging me just to reconstruct the building that's there. It's nicely built.
And I'm understanding of all of the costs that you are expending, that you have, told us on the record, but at the same time, some of these things were caused by you. So the correction needed to be paid for by you.
And I reckon, and I'm not trying to avoid my responsibility, Your
Okay.
Honor. I've told Mr. Martin this. I think he believes that I'm not trying to. St. John's Management District, I've been working hand in hand. Eric calls me, I call him right back. He wants some extra photographs of right now, I go out and take some photographs. That big log came down the river. I have no idea how that log came down the river. I mean, it went underneath my neighbor's bridge somehow.
Was it yours?
No.
It was from your
No,
removal?
it's not on my property. It was up the river and it floated down. It's this big around, Your Honor, and it's from me to that young lady long. And it is heavy. In the water, it's heavy. Mary and I were able to get it because it had lodged itself on top of that silt fencing, and that was making it not do its job. So I didn't want to just push it in the river and let it go down, so I tied a rope around it and tied my lawnmower onto it. So I said, it's not going anywhere. I'll get my grandchildren out there and we'll get that out of here somehow. And Mr. Martin indicated that they may have some people that can come out and help do that. But we were able to roll it off this fence, and then we spent the next 2 or 3 hours making sure the fence was up, and I went and bought new stakes at Home Depot and propped them up and stapled them up so that it's
Okay. Is there an amount of time longer than the 3 months that you think he would need, or taking into consideration the fact that he is always working with you Or do you believe that he could get all of these things accomplished in 90 days?
I believe, based on my experience in doing this for 30 years and based on the efficiencies within this county, that he can meet all of our requirements within the 90 days. And my stance on this is, as you're well familiar with, Madam Magistrate, is the 90 days or the 60 days or the 30 days or whatever the days awarded by you are an incentive for someone to not stop and to keep moving forward. And then there is a period of time that if they weren't able to do that based on no fault of their own, and they end up in a fine scenario, we have a process to bring them back before you and explain that process and settle those, reduce those fines or completely remove the fines. I don't want Mr. Moncrief to focus so much on deadlines down the road. I just want him to stay focused on the continuation of the efforts that he has started with and continue through those efforts until we get this accomplished, be it 90 days, 120 days, or 150 days, or 30. Whatever the process is, if he was to accrue any daily fine, we have a process in place to forgive those fines. And we're not above, sitting back down with Mr. Moncrief and his wife and going through the reduction of fine penalty phase.
Okay, I appreciate that. And also, the county has come back before me and said, look, we were the holdup in the process. We want to provide an extension or whatever, if that does in fact occur. So I think that the county has recognized that you're working with them by offering you the 90 days. Quite frankly, I've never seen a recommendation of 90 days before. That actually is more time than what I've typically seen. So that tells me that the county is mindful of all of the things that you need to accomplish in order to make this happen. So I think in your motion for an extension of time, you've actually been given an extension of time built in. Now, do you see a reason why you wouldn't be able to do, other than that you're dependent on third parties, why you would not be able to follow through and get these permits that you need in 90 days?
And if everything goes according to plan, we should be able to do it within 90 days, Your Honor. I expect that that Mr. Martin and his staff are working with me. I don't think that they're working against me. I do think that they are mistaken in thinking that I've done irreparable harm to the shoreline. I think that's, I don't want to argue it right now. I want to fix things.
So, unfortunately, that's something that we do need to talk about, though.
Yes, we do.
Because that is before me right now. And I have been given testimony that there has been a disruption, and the disruption in and of itself is considered irreparable. Because of a couple of different things, and the things I think that were most notable to me were that the flows of the river and the water levels are at a certain minimum to prevent flooding. And so I realized that maybe the water was in a certain area at one time on your property, but the natural way that water flows and the things that water does itself naturally, and the things that they did years ago and spending $4.3 million in order to clean it out, get the invasives out, put the naturals back in, it does its thing on its own naturally, and once it's disrupted by us, one of us, a human, without a plan in place, without a permit in place, that is guided by people who understand the process, you're right in saying that you can get a permit to go across. You're right in saying you can get a permit to disrupt things, but you didn't. And had you gotten a permit to do or to try to do what you were trying to do or trying to accomplish to put it back to where it needed to be, then you would have had those experts guiding you, and you could have done it in such a way that it wouldn't have caused any disruption. And unfortunately, we don't know whether it caused any disruption. We don't know whether down the road it's going to cost the county any money to do any restoration activities because of what occurred here. Because the natural flows were doing their thing, and they were fostering the habitats that are there. They were, there are things that that we probably didn't get near into the depth of regarding ecosystems and other things in the area that create themselves over time even. And while I understand what you were trying to do, I also unfortunately find that you were aware that the Water Management District did have a say in how the shoreline disruption is allowed. I mean, by your own motion and documents that you've provided to me, there were communications at one point with the Water Management District about something else that you wanted to do that was far too expensive. And so instead, you decided to go your own route, which is fine, had you gotten a permit to do it.
That was 8 years ago, Your Honor, but I understand. I do understand what you're saying, and it is my responsibility as the property owner to get whatever permits are supposed to be done, and I will try to do that. I just would think that if I had gotten, if I had applied for a dig and dredge permit, to be able to dig and dredge permit, that it's something that could have and would have been processed. I felt like I was restoring my own shoreline. I didn't feel like I was digging the river out. I'm sorry. If I would love, on the other side of the river, which is not where I had, there has been alterations upriver from me that is causing the flow of the river to eat that embankment away, and it's, I've lost about 5 feet of what was the little island across the river from me. And there's pictures of where the erosion has taken place in my motion.
Well,
But
and I know you don't want to share other things with the Water Management District in the county, but those kinds of things are important for you to tell. If there are things that are occurring upstream or downstream from you that are affecting your property as well, the county needs to know about that. They can't do anything about those things they don't know about.
I made them aware of it.
Okay, so I think that that's important as well. And I want you to know, I don't think that you did anything maliciously. I don't think that at all. But I do feel like you felt you could do it yourself and not go to this great deal of expense. And I don't know, you don't know, the county doesn't know what ultimately the impacts could be. So that is a concern to me. Now, but because I don't feel like you did it maliciously, that puts me in a little bit of a having to weigh. While I do think you did it intentionally, I think you did it yourself because you didn't want to go to the expense.
I'm not denying that I did it.
Right, so I'm kind of, between a rock and a hard place on how I should handle this. But I am going to find that you are in violation of Seminole County Code Chapter 40, Appendix A, Section 105.1 for failure to get the permits. We're going to get you getting those permits. I'll give you 90 days to do it. If for some reason there's a problem that's not on your end, I trust that the county will be back here and say, look, this is us. We need an extension of time.
Whenever you get a chance.
Sure. But so the county attorney has asked to speak before I go any further and make my ruling. Do you have anything else that you want to add before I let her speak?
I don't think that anything else that I have to say right now, is something that should affect what we're dealing with anyway.
Okay, and I also, for the record, am going to accept, does the county have any objection to me accepting his notebook into the record as evidence?
Good morning, Your Honor. Jennifer Nix, for the record, attorney for code enforcement with the county. I just wanted to ask, I was actually going to address whether the binder was accepted into evidence, and as far as the motion for extension of time goes, being a written 10-page, single-spaced motion, clearly the county did not have a chance to review all of this to be able to respond, to anything if we necessarily wanted to. I don't want to waive those kind of arguments later. So I just kind of wanted to address that if Your Honor accepts this into evidence, can we address that in the future? This isn't an emergency kind of written motion. A motion for extension of time can just orally be made and was addressed at the hearing, of course, but, the county can't be expected, nor can Your Honor, to have read every word of something that's submitted moments before a hearing starts.
Sure.
So
and-
if there are future things that are going to be submitted, like an extensive motion, if the respondent would please provide that in advance.
And I kind of touched on that at the beginning of your testimony. And I actually felt like he argued his motion here, and we kind of, because we are a little bit more informal, the actual motion itself, not accepted into evidence, it's being filed with us.
Yeah.
So I will accept the filing, and I will also accept the exhibits as evidence that you presented here. But I do agree that if you do have any future dealings with the county through the code enforcement process, you do need to try to get that information to them as quickly as possible ahead of time. In this particular setting, I think that we discussed the motion for extension of time kind of being rolled into what was being asked here anyway. So as to the extent the motion for extension of time meant you didn't want to be heard today, it would be denied. But I don't think that was the case. I take you presenting this book and what you've presented related to your case, I take that as you were meaning an extension of time to come into compliance, and I am willing to work with you on that. So to the extent it was not being heard today and this not being heard, it is absolutely denied, and we will make that clear in the order, but I will accept this binder into evidence.
Thank you, Your Honor.
Thank you.
Thank you.
Okay, so I am ready to rule. I am, like I had said previously, I do find that you are in violation of Seminole County Code Chapter 40, Appendix A, Section 105.1, unpermitted construction, and I am going to give you 90 days to work with the county to come into compliance with however that is. You have heard Mr. Martin testify that that may be a repair permit, or it may be a full permit. What is this? Yeah, I know. And so I will give you the 90 days, and I will, if you do not, and the 90 days would be by November 14th, 2026, that you have to have a permit. And if you do not have a permit by that date, or permits, depending on what all is required, it will be $500 a day that a penalty would be imposed until such time as you come into compliance. As far as Seminole County Land Development Code, Chapter 71, Section 70.6, for the shoreline alteration, I do find that you are in violation of that as well, and that it is irreparable and irreversible what you have done, because those impacts, while you are trying to restore as good as possible back to the original condition under the state and their requirements, I find that we are unsure of the types of loss of habitats and ecosystems, because this is and has been established as a very delicate water body. I think you've disrupted the minimum flows. I think that the purposes of how these water bodies are kept in their natural state for the anti-degradation purposes were disrupted by the activities that you engaged in. And for that purpose, I'm going to, for the irreparable, irreversible violation, I'm going to pose a fine of $1,000 to be paid within 30 days. And it will become a lien on your property if not paid within 30 days of the date of this hearing. Okay?
Thank you, Your Honor.
Thank you.
Thank you. Your Honor, may I be excused? I won't be here for the other
Yes,
cases.
thank you.
Have a nice
Thank
day.
you.
Thank you.
We only have 5 cases, don't we? Oh, okay. Okay, now we're going to call case 26706, Carlos Johari? Did I get that right?
Johari. That's not me, I'm the representative, but yes, it's Johari.
Okay, and your name?
Tommy Herrick with Any Trade Construction.
Okay, and Mr. Johari is not here?
He is here. He is
Oh,
present.
can he come up as well, please? Okay. You can have a seat. If you'll both raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Code Enforcement Officer Chris Smith. This case number is 26-725. Respondent is? Oh. Just kidding. I got 2 cases, just to let you know. All right, this one looks familiar. Case number 26-706, Johari Real Estate Services LLC. Parcel ID is as shown. The address is 407 Wekiva Springs Road, Suite 301, Longwood, Florida. This is within unincorporated Seminole County. There's no homestead on this, and this is unpermitted construction. The complaint was received by the building department, and it initiated originally in 2024. We're going through a lot of old building cases, so there's still a violation. Our initial inspection, since we started in October, was May 22nd, 2026. Mailed the notice of violation to the respondent on May 26, 2026, compliance date of June 10th, 2026, and did follow-up inspections on June 17th, July 17th, and August 12th, 2026, and the violation still remains on the property. This is the property appraiser printout that depicts the owner of the property, which is here today. On the the screen right now is the deed of the property, which shows Johari Real Estate Services LLC is the owner of the property. Here's the SunBiz showing the actual registered agent of the LLC. This is under code violation for Seminole County Land Development Code, Chapter 40, Section 105, and its permits are required. This is the compliance schedule that was mailed with the notice of violation on May 26, 2026, showing, in the corrective action, I quoted the permit number that they had on file, 25-10376 and 25-10376. These were the old voided permits. The new contractor that's here today is going to go over his side of it, but they actually have some permits I'll show you in a minute that they initiated. The photographs you're about to see are true and accurate, or what I observed on the dates noted. So that back in 2024, the building department, inside suite 345, the offices were changed into bathrooms, and they were tied into the piping of the building. This is on the 3rd floor of the main building, a lot of suites. And then when I initiated the case, you can see on May 22nd, the front of the property, and also it's the 3rd floor, I don't believe is being used right now. It's vacant, but it's locked. Here's my posting on August 13th, which I posted for this hearing, or actually on June 17th for this hearing on August 13th. This is my last inspection on the 12th of August, showing the interior, it's vacant and locked. The notice of hearings were mailed and delivered at the front desk reception for the owners on June 22nd. And this is the actual registered agent, same date, delivered. This is the old permit that was voided for the plumbing. And as going through just recently, there's 3 permits in the system for the same thing. And after talking with the contractor, he stated that he started the permits and had the wrong email address, so he had to add new ones. So most likely the 26-11360, which is in plan check, is the most recent one that's probably just awaiting to be finished and completed. And as you can see, the tenant showing 345, which is a suite, is the one that they're doing the work on. Here's all the permits that are in the process, the 3 that I stated. The top one is the most recent one, which is most likely the one that is the current permit. All of them are from the same contractor for turning the office space into a bathroom, suite 345. Based on testimony and evidence presented in this case, 26-706, it is determined that the respondent is Johari Real Estate Services LLC, the record owner of the property, and located at 407 Wekiva Springs Road in Longwood, Florida 32779 in Seminole County, as determined by the property appraiser records, and is in possession or control of the property and in violation of Seminole County Land Development Code, Chapter 40, unpermitted construction. And at this time, I would like to submit this digital and case file into evidence.
Do you have any objection to the electronic case file that has been presented and the code enforcement case being submitted into evidence?
No.
Okay, it will be accepted.
My recommendation is to comply with the code section cited within 30 days or a fine of $250 per day thereafter. This concludes my presentation.
Okay, do you have anything you'd like to add?
We would just ask for, instead of 30 days, we can get 60 days. Coming into this, Mr. Johari was under the impression that all of his permits were finalized out through the company. Unfortunately, the company, when I spoke to the building department, you have 7 days after you apply for a permit to finalize a permit. Get the permit application in, get everything situated. They did not do that, so the permits got voided. So I'm just going through the process, getting all the permits pulled, and et cetera. I would ask for, are you asking for 30 days for the permits to be issued and finalized out?
Yes.
No.
Okay.
Oh, issued and finalized out.
So I would-
per my compliance schedule, yes.
Okay, so I would ask for 90 days on that, just because I'm not sure what the building department is going to come back with. I've already had to fill out multiple discrepancies. amongst one being the parcel number didn't match the property. We had to go through property appraiser. We had to change stuff up. And that's the only reason I asked for that, Your Honor.
On the bottom of the corrective action on the far right, with pass and final inspections.
Is that under 105.1?
Here's 105, permits required.
This provision doesn't say with the closeout.
No, what deems to happen is they come in and get a permit initiate, and then they stop the work and don't do anything, and then it voids after 6 months.
So
What's your recommendation?
Well, because so during that 6-month period, if they have the ability to, I wouldn't be able to impose a fine for not getting a closeout. I would have to give them at least 6 months from the time that they got the permit, because they're allowed that much under your code. Then if they are permitted to have an extension for any reason, so I don't know that I can give any kind of closeout penalty. I think I can only give getting the permit, and then you all would have to open a new case if they don't.
Sounds good.
Okay, all right. So is there a reason why, with you involved now, that you wouldn't be able to get the permits in 30 days?
No, I believe we can. I have worked with Seminole County Building Department for a number of years. They're
Okay.
very unique when it comes to submitting stuff, and they're very proactive in making sure everything's correct. So sometimes it's a little difficult to go through the process. That being said, this is just a simple plumbing. They added 2 toilets and a sink and 2 office spaces. That's why there's 2 permits pulled, one for 325 and one for
345.
345, correct? So I just want to give myself enough ample time to make sure that we can go through, get all the permits issued. The building department can come through and do their inspections properly. Speaking with Chris, I don't think it's going to take more than 30 days, but I would like to give myself that extra leisure of knowing that we can get it done for sure.
Okay, so I'm not willing to give you past September 14th, because I also feel like you need to remain on this, and if you get more than, sometimes we get relaxed and blame it on, oh, well, I didn't get this or didn't get that. So if you've got a time frame, you're going to stay on your people, and they know what the time frame is too. So I would rather go with, and then if you can't do it on the 14th because of something that the county does, I have full faith that you would be back here telling me that.
Yeah, absolutely. I mean,
Okay.
it's already done. So at this point, the building department's going to come in. It's at a final inspection stage.
Okay. Then I will give you until September 14th to get the necessary permits. And if you do not get the necessary permits, there will be a fine imposed of $250 a day for each and every day that the permits are not secured.
So is that the permit's not being finalized out, that is just securing the permit?
Just
Okay.
issued.
Which
Yes,
they
sir.
should be, I would imagine, later today.
Hopefully.
Oh, yes.
May I make a comment for the record?
Sure.
I'm Dr. Jahari. I own most of that building. I bought it many, many years ago, 2009, when I first started buying it. I'm not one to do anything without pulling permits, obviously. I own several dental offices and other properties, so I'm well-versed in real estate. I did pay a licensed plumbing company to pull the permits and do the work, and obvious by the permits that were initiated but voided. So I feel real bad being here. They initiated the permits. They never filled out the paperwork. They gave it to my wife. She's not in construction. They wanted her to fill out all these pages of information. So finally, I ended up hiring Mr. Herrick here. So I did pay for permits to this company, and they failed pulling it, and that's why we're here today. I don't want anybody thinking that I'm doing something illegal or wrong. No electric was altered. No walls were moved. Tile was put in. The furnishings, toilet and sink was put in. It was plumbed into existing plumbing there. Right, the adjacent walls are existing bathrooms. They're handicap accessible bathrooms, pre-existing. So we were very fortunate to have the plumbing available, and that's all they did was tie into the plumbing. It wasn't a real big deal, and I'm sure he went and saw it. It's not a problem. I do want to clarify one thing. No, it's not really occupied, but it is occupied. Me and my wife have our offices up there at the other end. The doors stay locked. And we have storage facilities there. Because this is a big building, all the ACs are on the roof, and to access it, to work on them, they got to go to the third floor through the attic access onto the roof. There's no external staircase or any way to get onto the roof. All the AC units are up there.
Okay. Well, I
just wanted
appreciate
to clarify that I'm sorry we're in this situation. He's confident, I'm confident, and maybe the inspector's confident. It's just to get in there, look at things, and sign it off. There's nothing. That has been done a while back. There's been no leaks, no complaints, no problems. It's all by code. It was a reputable company. Excuse me for saying this, but English is not their native language, so maybe that's why they had a problem with the paperwork filling it out. But the work was impeccable, and they do have a license. So
Thank you
sorry
for
we're in
clarifying.
No problem, thank you.
All right, thank you.
Yes, ma'am.
Okay.
Good.
That's all? Yep.
Thank you.
We're good.
I gave you my card, right? Oh, I gave you it. Appreciate it.
Yeah, I have it. I'll get it to you. Okay, the next case is 26-725, Michael Group, LLC.
Now it's your turn.
Hi.
Sonia Sandoval, my name.
Good
Okay.
morning, I'm Jonathan Sandoval.
Okay, can you please both raise your right hand? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Code Enforcement Officer Chris Smith, case number 26725. Respondent is, this time, Mikhail Group LLC, parcel ID as shown on the screen. Address is 3530 Celery Avenue, Sanford, Florida, within unincorporated Seminole County, Florida. This is no homestead on the property. Description of violations is unpermitted construction. This was originally received from the Seminole County Building Department for unpermitted construction. The initial inspection I had was on May 22nd, 2026. Notice mailed to the respondent May 26, 2026, and compliance date was given June 10th, 2026. Follow-up inspections were conducted on June 17th, July 17th, and August 12th, 2026, and violation still remains on the property. Here's the Seminole County property appraiser showing the current owner of the property, which is Mikhail Group LLC. This is the deed showing the current owner of the property, same thing, Mikhail Group LLC. Because it's an LLC, this is the registered agent under Sunbiz, which is Maria Sonia Sandoval. This is under code violations, Seminole County Code, Land Development Code. Chapter 40, Section 105, which is permits are required. And with this is unpermitted construction. This is the compliance schedule that was mailed with the notice of violation on May 26, 2026, which does state with pass and final inspection, which it'll be only for the issued permit. There was a permit that was filed back, and it's 25-4 4543. It was initiated and never followed through. It's in plan check, which is still there at this time. The photographs you're about to see are true and accurate to what I observed on dates noted. This is all the new windows and some of the exterior and interior alterations on the property. This is initial inspection. The house is currently vacant. And here's my post-in for, on June 17th for this hearing on August 13th. My inspection yesterday, house is still in the same condition. The mail for notice of hearing was mailed to the owner and delivered on June 20th, 2026, and signed for. Oh, and this is the registered agent, also signed for on June 20th for notice of hearing. This is the alterations permit that was initiated, and it's accepted back in, what, October of 2025. This is, there's still some comments and stuff that needs to happen before the permit is issued. It's still in plan check, and it's been sitting with the applicant now for 276 and counting days, depending on what day this was pulled. And this is what the alterations permit's for. It's to demo interior walls, ceilings, drywall replaced, so it's a lot of interior and some exterior, and windows and exterior doors. These are all the permits that are on file right now. There's 2 voided ones for replacement of the AC, the alterations, which is in plan check. And then the electrical one is issued, and this ties into some of the stuff that's going on with the alterations, and the re-roof is issued. So they doing some of them they got already issued. It's just waiting on the alterations. Based on testimony and evidence presented in this case 26725, it is determined that the respondent is McHale Group LLC, the record owner of the property located at 3530 Celery Avenue, Sanford, Florida, in Seminole County, as determined by property appraiser records, in possession or control of the property and in violation of Seminole County Land Development Code, Chapter 40, Section 105, unpermitted construction. At this time, I'd like to submit the digital and case file into evidence.
Do you have any objection to the electronic case file being submitted into evidence?
No, ma'am.
Okay, we'll accept it.
My recommendation is to comply with the code section cited within 30 days for the permit to be issued, or a fine of $150 per day thereafter. This concludes my presentation.
We don't have any objections. The only thing we would ask for 60 days for the permitting, only because the contractor that we hired, he just underwent knee surgery. He actually resubmitted the permitting needed, the electrical, which was he showed that was issued. We're just waiting to hear for the county back, letting them know that the permit was issued, and we can continue forward with the work. I think, continuing forward with the work, we'd ask for 6 to 8 months to finish and complete for final inspections. We might get done sooner, but, stuff may happen, you know how it is sometimes with construction. So that's why we're asking for at least 8 months.
So we're not here for that today? We're only here for the receiving the permit?
Well, we're just waiting to hear back from the county, because we already filed, as this morning when I spoke to him, he filed it in, I believe, Monday, Tuesday this week, and he's been calling since then, but he hasn't heard anything back. So That's where we're at this point.
So I'm confident then with the 30 days, because I feel like his knee surgery, he'll still be able to make, it sounds like he's still making calls and stuff. So I don't, I think that the 30 days is plenty. The county is generous. This is not a homesteaded property by giving you $150 a day. I would have typically imposed $250 a day for a non-homesteaded property, but I feel like you're working toward what you need to work toward. I see that there have been permits that are issued. So I will accept in this particular situation, you will need to have your permit pulled by September 14th, 2026, or you will have a fine of $150 a day imposed for each and every day thereafter until the permits are received.
Okay.
Okay? Thank you.
Thank you, Chris. I appreciate it.
Thank you.
And we'll be, yeah, I'll definitely contact you. Yeah, so perfect. Yeah, okay, awesome, thank you. Yeah, appreciate it, brother.
Next case, 2639 Philip
Thank you.
Kavasevich. Savage? Kova Savage. Okay, yes, sir, thank you. September 14th. Mr. and Mrs. Kova Savage, if I could have you raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? Thank you.
Inspector Katina Hill, case number 2639. Respondents are Philip Kovovich and Sandra J. Kovovich. Parcel ID is shown on the screen. The address, 1846 Long Pond Drive, Longwood, Florida, 32779, within unincorporated Seminole County, Florida, and its property has a homestead. The description of violation, the storage contract equipment, semi-trailer / materials on the A1 zone property is prohibited. This came in as a citizen complaint. My initial inspection was January 14, 2026. The notice of violation was mailed to the respondent on April 29, 2026, with the compliance date of May 14, 2026. The follow-up inspections were 3/27, 5/13, 6/30, and 8/10, all of 2026. And as of today, those violations remain at the property. The next one is the property appraiser showing Philip and Sandra Kovovich as the property owner. And this is the deed that also shows Sandra and Philip Kovovich as the property owners. The code violation is Seminole County Land Development Code, Chapter 30, Section 30.5.2 is the prohibited. This is the use table of the storage of contractor equipment and semi and materials, and as you can see where it's highlighted, is not allowed in the A1 zone property. This is the compliance schedule that was mailed with the notice of violation on April 29, 2026, that gives them a compliance date. The photos that you are about to see are true and accurate representation of what the officer observed on the date noted. So my initial inspection, as you can see back there, the gray thing, that is the semi-trailer that is in the backyard of the property. This is my follow-up inspection. It still remains there. This is another follow-up inspection where I went to the property, I left a door tag, and the violation still remains. This is the notice of hearing that I posted for August 13th, that I posted on July 20th for the hearing for today. And on my follow-up inspection this is another follow-up inspection where the trailer remains back there. And my last inspection, as you can see, the trailer is still at the property. This is the certified mail that was delivered to Philip and Sandra Kovovich. Based on the testimony and the evidence presented in case 2639, it is determined that the respondent is Philip Kovovich and Sandra J. Kovovich, the record property owner located at 1846 Long Pond Drive in Longwood, Florida, is in Seminole County, is determined by the property appraiser, and is in possession of the property and in the violation of Seminole County Land Code, Chapter 30, Section 30.5.2, prohibited use table and footnotes. And at this time, I would like to submit this digital case file into evidence.
Do you have any objections to the electronic case file being submitted into the record?
No, but I'd like for her to be able to say Kovacevich, please.
Kovacevich, sorry.
Thank you. I don't have...
She's got one more slide.
My recommendation is to comply with this code section within 15 days or a fine of $250 per day thereafter. This concludes my presentation.
I will go ahead and accept the electronic case file into the record. The county has closed its case. Do you have anything that you would like to add?
Yes, we were presented with this photo of the types of equipment that can't be stored on property. And basically, none of these match up to the piece that we have that she's been investigating. And that piece that we're speaking about has moved on the property and is being utilized in our finishing up our building that we added in the back of the house. And it also played a role in a 2015 occurrence where we had a sinkhole on the property and the whole house had to be evacuated. We notified our insurance company, who said that they would take care of the house and pay it out. And a week before this meeting was to take place, the company went bankrupt. So we ended up with the state. State only pays $550,000. They expended $550,000 within less than 6 months. They utilized a company to evacuate all the gear that we had in our garage and tape it up and put it in pods, and they charged $21,000 to do that. So we had little to say, but we forced the issue to be able to utilize some of the equipment that we have, which was that trailer. This was in 2015, through our contractor that was working to restore what the company did that took the house apart. And it was accepted because we were able to utilize it in getting rid of the humidity inside of it. It sat there for about a year and a half through, all the way through 19, I believe. 2018. And served its purpose. It went back to our location and wasn't brought back to our house for use until 2/27 of 25. And we have photos, we have documents that show payment to the driver that delivered it, where it's sitting, how it's sitting, and the purpose of it. I also had a little bit of difficulty in finishing this new project that I started, which I permitted, which was for a building to be erected on the property. We started the process by pouring a pad and pouring a permit. It was a 60 by 80 concrete pad, 8 inches deep, 12 by 12 footer around it. We waited about 2 months before we started building the rest of the building around it, allowing the concrete to harden up. So we only pulled a permit for the concrete, not for the building.
Sir, I'm not concerned about the permit for the building. I'm concerned about this particular,
The purpose for the trailer.
the storing of the trailer, not even the purpose, because it's not allowed. So
Can you show me which vehicle it is on this list that?
I don't know what that list is, so I can't show you
This is the
anything.
one that was presented to me by her.
May I
And it
interject?
doesn't represent any of them.
Code Enforcement Division Manager John Martin. The list in front of you, sir, only pertains to parking. I'm not exactly sure why you were given that list, but the violation you were cited for, 30.5.2, calls for contractor storage in a R1 zone district is not permitted. You do have an active permit, but the shed, the Connex body, or semi-body is not named in that permit as storage for equipment for the project, the purpose of this project. Does that make sense? In order to have that box on the property permanently, you would have two options. One, it would have to be attached to an active building permit pertaining to the principal structure, or two, you would have to permit that thing as an accessory structure.
Well, that's not what we were told by the county. The county told us that all you need to do is apply that permit and you were able to do exactly what it says on the letter we got, that it can be utilized for
Storage of materials during the process of the renovation while the permit was active.
Exactly what it was there for. Let me be clear, I don't want this truck in my backyard either.
How long do you anticipate before you are finished with the project and the trailer would be of no use to you?
And let me interject real quick. I mean, reasonableness, because to me, waiting for concrete to dry for 2 months is not reasonable. So,
Your Honor, we have a 45-foot-long bus that weighs over 60,000 pounds, which outweighs most of the vehicles on this list. I had 57 concrete trucks loaded on my yard during my sinkhole operation to restore the building. The house basically collapsed. I've gone through a lot of stuff with the county and with the state, and lots of things have been said and done incorrectly. I would just like to get my house back to me without anything in the back, cars, trucks. That's why I built the building. It'll house my bus, house my boat, it'll house my dually pickup truck and the cars and some other material.
Mr. Martin, can he amend his existing permit to allow for this temporary structure?
You can. And that's what my question was, is how much time before you're finished with that building?
Okay. I'm 74, she's 74.
You look great.
We're both doing it together.
You both look great, by the way.
Thank you. Thank you.
Well, if I may interact too in this a little bit. The trailer came back on our property on the 27th of February of '25, and with the intention of going ahead and using the materials and everything that are in the trailer to finish up what we need to do in the new building. In the meantime, my husband has been hospitalized 3 times this year, last year into this year, for a total of almost 30 days. And then, on top of that, he had to be at the house. There has to be a nurse for 4 months coming. So it kind of slowed us down. Right. You know, it's like, I don't like looking out in my backyard. In fact, I probably bitch about it more than anything.
I was just going to say.
But I'm saying, when is this going to get going? When is this going? But he's feeling better. We have the permit to do the electric and other in the building now. So, to finish the insulation, yes, we got to do that. So if we can have just a little bit longer to have that trailer there.
Do you feel as though 90 days you would be able to have that trailer?
I think so. That's what I was hoping for.
No, I have no objections to changing my recommendation to 90 days and $150.
Okay.
We share the same goals, obviously. None of us want to look at that trailer anymore. So.
I just don't want to hear it from her.
She knows where you sleep, sir.
And he's going to be sleeping in that camper under the new building.
Yeah. 60 years we've known each other. 55 we've been married.
Very nice, very nice.
So we have no intention of...
So 90 days is fair.
Yeah, 90 days is fair as long as my health. I had open heart surgery. My last was Christmas in the hospital with sepsis, and rehab didn't get me out until
January 19th.
And then rehab was until May.
Yeah.
And I want to assure you, as you already saw in a previous case, we have everything goes wrong, and you extend the 90 days, and it's 120 before you get done. You have a window of time that you might accrue a fine. We have a process in place to reconsider that, remove it, reduce it, whatever. That's up to her discretion. But we're on your team. We're not your adversaries. We want the same goals when we get to the end of this. If you're under 90 days, great. No issues. If you're over 90 days, great. Let's walk through the issues of getting the fines reduced or removed completely.
Okay.
So focus on completion. Don't focus on the end of it, and I think we're going to be great.
Every day we focus on it.
Absolutely.
So then, would we, in the 90-day period, will he, prior to that, he's going to need to amend his permit?
I would, and I'll walk over to the building with him and ask if they can put a notation in the system allowing this on the property for the purposes of housing materials until the permit is closed. And that
Okay.
way, understand this is all as a result of citizen complaints between stuff, so we're just trying to cover all the bases.
Okay.
I'll walk him over there, we'll get something added to the note that says it's there for the purpose of this, for the duration of till the permit's filed.
Okay, I'm still going to include in my order that you're going to go with the county to get it put in your permit, because I want to make sure that you do that part, because I think that that's important, because that covers the county as well, with it being part of your permit.
Okay, well, this here states exactly what we're about ready to do.
Okay.
That it's allowed to,
And is that
Be there.
on your permit? Is that your permit? Is that his permit?
I have the permit
This
here,
is
but-
an email that I sent to him about the trucks that they can't be
there's
stored or
underlined
parked
what
there.
it says that we could do.
No, he looks like he has something else.
I'm going to take, me and you walk us over to the building.
Okay,
Okay, and we do have the permit, yeah.
The trailer's there for.
Okay, fantastic.
All right,
because they told us we could do it.
Yeah, but I would have it in writing on the screen, on the.
I would as well. So then we'll include it in the order that you're going to take the necessary steps to amend your permit to reflect that you have this structure temporarily on the property. And then I'm going to order that you do not have this on your property for longer than 90 days.
All right, so I have one more question, if I may, Your Honor. The building that we erected houses all that equipment that I mentioned. If I needed to work on that trailer, could I bring it inside that building and work on it?
Anything you do within the confines of that building are legal.
Okay.
Except illegal stuff, obviously, but.
Right.
Yeah, if you were to bring it in there, put it inside of it to work on it, when you're finished working on it, hook it back up and take it back to where it lives permanently, absolutely not a problem whatsoever.
Okay, that's great.
And I would appreciate it if you could give Officer Hill a call or an email that says, hey, on Friday, I'm going to have to bring the trailer by for a couple weeks. In
Right.
case there's an issue with people, we can go, yes, we're aware of that and we're taking care of it. So we can
Okay.
avoid all of this headache in the future.
All right.
Okay. And so I'm actually going to have you have the structure removed by November 16th, 2026, or a fine in the amount of $100 a day will be imposed if you do not move it. But like Mr. Martin has indicated, the county is willing to work with you. If the fine does get imposed for some reason, they would work with you after the fact.
Thank you very much.
Thank you. Case 25-273, O'Grady Real Estate Incorporated. Could both raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Code Enforcement Officer Shannon Henson, case number 25-273, respondent O'Grady Real Estate, Inc. The parcel ID is identified on the screen, and in the case, it's a vacant lot on Elm Street in Oviedo, Florida, within unincorporated Seminole County, and there's no homestead. The description of the violation is storage of recreational vehicles on a vacant parcel, truck parking, weeds, and accumulation of rubbish or garbage. This inspector is myself. This was a citizen complaint. The initial inspection was October 3rd, 2025. Notice of violation was mailed to the respondent December 17, 2025, with a compliance date of January 8, 2026. There were follow-up inspections on December 9, 2025, January 15, 2026, March 2, 2026, June 1, 2026, July 21st, 2026, and then yesterday. The results of the inspection is the violations, part of them at least, remain on the property. This is a copy of the property appraiser's sheet showing who the owner of the property is. And this is also the deed showing who the owner of the property is. And this here is the Sunbiz showing who the registered agent is, which would be Mr. O'Grady. And the violations are Seminole County Land Development Code, Chapter 30, Part 5, Section 30.5.2, transient parking of recreational vehicles or campers, 30.9.4, truck parking, and also Seminole County Code, Chapter 95.5, Section 302.4, weeds, and 308.1, accumulation of rubbish or garbage. This is the compliance sheet that was mailed out with the compliance date of January 8th, 2026. And the following photos you're about to see are true and accurate to what the officer observed on the dates noted. This here was first observation back in October of the overgrown grass, and here is the camper in December, and the overgrown grass and some of the rubbish. This here's in January. The camper was still on site, and there was different articles of material and stuff that they had for like construction, probably. This is March 2nd, 2026. But you can see the grass is pretty cut there, but there's still objects on the property that weren't supposed to be there. And this is June 1st, 2026, where you see different things were brought onto the property and the grass is starting to get overgrown again. And this is when I posted the property, June 25th, 2026. And this was yesterday. Oh, no, I'm sorry, this is July 21st, 2026, where the grass is overgrown again. You can see some of the items that were left out there. And then this was yesterday. The grass has been mowed. Mostly what is left right now is the rubbish and garbage. You can see one vehicle is now being towed off the property, so that was like the last vehicle that was actually left out there. This is the copy of the mailing. This one was returned unclaimed. And the next one was also returned because it was a vacant parcel because I mailed it to the actual property. And then this one here was delivered. And this one was also delivered. On the basis of the testimony and evidence presented in case 25-273, it's determined that the respondent is O'Grady Real Estate, Inc., the record owner of the property located at the parcel number 2520-315BA 0000175A in Seminole County is determined by the property appraiser's records to be in possession or control of the property and is in violation of Seminole County Development Code, Chapter 30, Part 5. They were in violation for the transient parking and the truck parking. And then Seminole County Code 95.5, they were in violation of the weeds. Those are no longer there. Right now, the violation is Section 308.1, accumulation of rubbish or garbage. At this time, I would like to submit this digital and case file into evidence.
Do you have any objection to the electronic case file being submitted into evidence?
No, we don't.
No. Thank you. It will be accepted.
The recommendation, violations for Section 30.5.2, transient parking or recreational vehicles, in Section 30.9.4, truck parking, and Section 304.4, weeds, were in violation and now are in compliance. For the remaining violation, Section 308.1, accumulation of rubbish or garbage, to comply with the code section cited within 15 days or a fine of $250 per day thereafter. This concludes my presentation.
Thank you. Do you have anything you'd like to add?
Hi, yes. We want to start with we want to apologize first that it took so long, because honestly, it did take a while. But due to some current financial restraints, we are actually going to end up having to sell our properties. So we've been establishing, kind of organizing. We've got lots of equipment and things out there. There's a pole barn with all kinds of construction equipment and things. We're organizing everything, and we're having an estate sale next weekend. We have gathered all of the trash together. We do have heavy machinery like a dump trailer that we will be using to get rid of all of the rubbish. And we have a skid steer, like with lots of attachments, which is how we used to maintain our lawns. But as you know, a lot of those things require maintenance, and it was broken down for quite a long time. So we ended up having to rent heavy machinery to mow all that down to be in compliance, and we've done that. There's just one more little thing that we need repaired on our skid steer so we can finalize everything, and we need to do a little repair to our dump trailer. So after this estate sale, we know that there will be some remaining rubbish that we would like to combine and just do one final load in that dump trailer to get rid of everything. We will be in compliance, and we're hoping 15 days, but we're asking for 15 more, just a total of 30 days to make sure that we don't come across any other issues, because repairing these things sometimes is very expensive. And as you know, like I said, we're doing this because of financial restraints. So we're just hoping that there's no more issues, but 30 days is what we're asking for.
Does the county have any objection?
No objection.
Okay. So I'm going to kind of do this in two parts, because I need you to understand the importance of the violations that you are in compliance with now. If you were to, on any other properties, have these same types of violations, because you know now what the code says, you know how you're supposed to operate, if you are found to be in violation of these codes on this property or any other in the future, you stand to have a penalty of $500 a day imposed, because now you have notice. So I'm going to go ahead and find that you were in violation of Seminole County Code, Chapter 95.5, Section 30.5.2 for storage of recreational vehicles on vacant land. I'm going to find that you were in violation of Seminole County Code 95.5, Section 30.9.4 truck parking, and you were in violation of Seminole County Code 95.5, Section 302.4 weeds. Now, let me emphasize the weeds one, because it's very easy in Florida for us to have overgrowth that occurs on our properties, and especially if we're not there every day and we're not maintaining them. This will be an expensive yard mow if this happens again. So please maintain the weeds. Please make sure that you do not accumulate trash or anything on these properties any longer, this one or any others that you own, because now you have that notice for any other properties that you own as well. And then I'm going to find that as for Seminole County Code Chapter 95.5, Section 308.1, you are currently in violation of accumulation of rubbish and garbage, but I'm going to give you until September 14th, 2026 to come into compliance with that, or you will have a penalty of $250 a day imposed.
Okay, I just have one question. Section 35.2, it says there is limited use for recreational vehicles. Is that correct?
Not on a vacant piece of property, no.
Can you, I mean, when we look it up online, there is an L next to that table for A10. Is that not correct?
Chris Smith, Supervisor Code Enforcement. What that is if you were building on that property and doing something construction-wise, they would allow a limited use permit, but you just can't get one just to have the vehicle there. It's you working towards another, usually when people are building, they can live in it while they're building or constructing on the property. So there's no active house on that. There's just the the barn and the shed. Nobody would be living there. You wouldn't be able to get a limited use permit just to
Even
store
for
it.
storage?
No, sir.
You can't? So
Well, the
doesn't-
reason we ask actually is, I did mention to Shannon, so we ended up moving the RV to another location. But where it is currently, it doesn't have any electricity. And as I mentioned, we are trying to have an estate sale. So I asked Shannon if it was okay that we bring it back. There's electricity out there and a hookup. So if we could bring it back and plug it in just for our estate sale, because the people who are buying want to see that it works, that it can be plugged into electricity and all this. So I asked if we could put it there just for the weekend of our estate sale to sell it.
So you have 30 days now with this order. So if you bring that back and leave it there for the 29 days and work with us, even if it went a day, I'm not saying go a day over because that would be in violation, but as long as you're staying in contact with us, we know what's going on, it'll be a little easier. Also, if you put that RV on a structure in Seminole County that has a house, you can park it on the property anywhere as long as there's no setback requirements, no permit requirements. You can store an RV on a property in Seminole County. You just can't live in it.
Okay, so the 30 days actually goes to the accumulation of rubbish and garbage. And I found you in violation of the other, but they're saying they're going to work with you.
Yes,
So
we'll work with
they're not going to, they're not going to come out and immediately violate you again for this, so.
Okay.
Thank you.
Absolutely. Okay, thank you. Because I did not approve the minutes prior, I'm going to approve the minutes from July 9th, 2026. We do have other business, the vacating of the order, prior order 2656.
What's that? No, I'm just trying to make sure that I didn't get this deleted from
No, the vacation of the order,
Does John have anything?
2656. I believe it was just requesting, because there's a Liz Pendens that was filed and it was found subsequent,
Yes.
that you're asking for a vacation of my prior order.
Yes.
I absolutely will go ahead and vacate my prior order. You all can record that. Actually, my order wasn't recorded, was it? It was recorded? Okay, so the recorded version is not in the file? Oh, it's only electronic, okay. So then, yes, I will vacate my prior order, and then we will, it will need to be recorded as well. Okay. That is all. I will confirm the next hearing is September 10th, 2026. We are adjourned.